Good morning, ma'am.
Hi, good morning, Your Honor.
Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail.
Boom! Right away. The courtroom sets the tone. A DWI charge isn't just a ticket, it's a life disruptor. Jail time, fines, record damage. And here's the hook. Is this a one-time mistake or the start of something much bigger?
And or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. And this is
Okay. On July 27th, 2024, at about 9:20 p.m., officers arrived on scene and observed two vehicles that had been involved in an accident. The witness stated she had been stopped at the light when she had been struck by the defendant's car. The witness stated she saw the defendant to be the driver of the car that struck her. The defendant stated she had been downtown and was on her way home. She admitted to having one beer. Standard field sobriety tests were conducted. A 6 out of 6 was recorded on the HGN. A 7 out of 8 on the walk and turns.
Now pause right here. This is where science meets the law. Field sobriety tests plus a breathalyzer. Reading nearly double the legal limit? That's powerful evidence. But here's the twist. In court, it's not just about numbers. It's about whether the process was done correctly.
3 out of 4 on the one-legged stand. The DIC was read and the defendant consented to a breath test. The first result was .175 and the second result was .181.
All you said is there's an accident and she admits to one beer. Were there any slurred speech, bloodshot eyes, odor of alcohol?
Sure. Didn't summary to that. It looks like we just have the car crash and the admission.
Judge, can you hear me?
Yeah. Can you hear me?
Yeah, I'm here. Yes, sir. I'm sorry. I'm down in Galveston. Yes, sir. I'm here on Mrs. Morales.
Yeah. She's actually right in front of me right now, Michael.
I see it. Perfect. That's why I jumped on.
Have you heard PC yet?
No, sir.
All right. Do you mind reading it one more time?
Okay. Absolutely, Your Honor. On July 27th, 2024, at about 9:20 p.m., officers arrived on scene and observed two vehicles that had been involved in an accident. The witness stated she had been stopped at the light when she had been struck by the defendant's car.
The short answer.
The witness stated she saw the defendant to be the driver of the car that struck her. The defendant stated she had been downtown and was on her way home. She admitted to having one beer. Standard field sobriety tests were conducted. A 6 out of 6 was recorded on the HGN, a 7 out of 8 on the walk and turn, a 3 out of 4 on the one-legged stand. The DIC was read.
Wait, did that just happen? A 0.181 BAC and still no probable cause? That feels like a shocker. But legally, it makes sense. Probable cause isn't about proving guilt beyond a reasonable doubt. It's about whether the officer had enough observable evidence at the scene. No signs like slurred speech or odor. That gap just changed everything.
Breath test was given. The first result of .175 and a second result of .181.
I didn't hear anything about any kind of slurred speech, odor of alcohol, bloodshot eyes. I didn't hear any of that, Michael, so I'm just finding no probable cause.
Okay.
You know, Miss Morales, we have enough destruction on our streets, enough death from DWIs every single day. You know, if you're gonna drink, if you wanna have 15 beers, 32 shots tequila, one button on your phone, $40 with an Uber, will get you anywhere you wanna go. Use it.
Sir.
Please.
Yes, sir. Thank you, Judge. I'll talk to you later.
Thanks, man.
And now the tone shifts from legal to personal. The judge isn't just talking to her. He's talking to everyone watching. This is the real-world consequence of impaired driving. One bad decision can ripple into tragedy. So let me ask you, how many people gamble with this every single night?
Yes, I.
I'm not happy with you, man. You now,
What's the one who picked up the PCS in felony court and they end up dismissing it?
right, you're on probation in our court. A motion to revoke has been filed because testing positive. Oh, she picked up a criminal case. You picked up a PCS. Failing to blow in your device, failing to participate in program. So for now, I'm gonna have you take your seat in the jury box. Do you have a lawyer here today?
No, sir.
Okay, I'm gonna appoint your lawyer today, and then we're gonna talk about how we go forward. Take a
Thank
seat.
you, sir.
You're not allowed to leave. Please.
Your Honor, so the state has filed a motion to revoke community supervision on Ms. Gonzalez. I just spoke to Ms. Gonzalez about each of these, and so I'd like to be able to respond to them before the board if possible.
Sure.
Well, I would ask them to start with their motion though, actually.
So here's the deal.
Yes, Your Honor.
I have a lot of history with Ms. Gonzalez, a ton of history you don't know about. And we've gone round and round with her testing positive for alcohol, pills, meth, cocaine, alcohol, and it's literally been over and over, and it's been over. And now while she's on this probation, she tests positive for meth.
The night she tested positive for amphetamine, meth, and opiates, and on the March 5th, she tested positive for THC. She's also had skips on her device, 12 in February, 5 in January, 8 in December.
So I really think, and I warned her at the outset when she got on the probation that it was a problem, that I was going to put her in treatment. And I think that this is truly the only appropriate way to go forward, because
Here comes the bigger picture. This isn't about one incident anymore. It's about history. Multiple positives, missed tests, failed compliance. In the courtroom, patterns speak louder than promises. And right now, that pattern is loud.
do this on her own, and we multiple times, and it's just not happening.
I have signed up for treatment, sir.
Ours is better. And I think that that's really the only appropriate course of action. So what I'm going to do is I'm going to amend your conditions to go into treatment. I think that that's, the evaluation is to do Hue.
Yes, go ahead, I'm sorry, ma'am.
In terms of the treatment, Your Honor, is it that you are wanting it to be jail-based treatment, or could it be facility?
No, I used to use,
Yes, correct. We're helping ourselves to Tascasita. It's a 36-month program based on how to respond.
Your Honor, I have my father at home by himself, Your Honor, who's,
gave you the opportunity, ma'am.
may I speak to you
Not gonna-
openly? Just for a second, Your Honor?
No, I've heard it before. You've told it to me time and again, and I've heard it time and again. And I'm sorry, but, we gave you the opportunity. You're testing positive for these.
Please. So, Your Honor, I think when I spoke to her before, the only thing that we were talking about in terms of possible failed drug tests was a test that I showed from last month for marijuana. And so her explanation for that, Your Honor, is that she has broken her arm and
This is a courtroom's toughest balancing act. Compassion versus public safety. She's caring for her father, but the judge is responsible for protecting thousands of people on the road. So what wins? Personal hardship or community risk?
two different places and pain management issues. Until we were here now, I'm only hearing about these other things. The only reason I bring it up, Your Honor, is because if she is having some type of issue with substances, I support treatment. I just question whether the jail-based treatment is the only possible option. Like, could she go into custody and be transferred from there into a facility where she has to be inpatient for 120 days or however many days you're requiring? Does it just have to be who? I guess is what I'm asking.
Here's the thing. Every time that I've done a TRAS on someone and have deviated from it, we've paid for it dearly. They've either picked up a new DWI, a felony, and I really take homage in the TRASs because I tell you, every time we deviate from it and I acquiesce to something that you guys want or defense wants, we pay for it dearly and they end up in a worse position. And so that's why this has been an ongoing battle for 2 years. We've had an ongoing battle with Ms.
Listen carefully. This is experience talking. The judge is basically saying, every time I've given leniency before, it backfired. That's huge. In law, past outcomes shape future decisions. So even a reasonable request now might get denied because of what happened before.
Years where it's been nonstop testing for this or testing for that, and I can show you the proof. I've got the proof. And now while she's on bond, she picks up a felony PCS. She's testing positive for these things, you know?
I would just add the felony PCS was
I get it.
dismissed
I get it.
It's my medication, sir.
within 5 days of it being filed. So
I understand. I get it. But I really want to do what the TOS. You know, I'm sorry, man, but that's what we're
I
gonna
can't
do.
leave my father, sir.
These are things that you think about when you're out there in the free world. We gave you the opportunity, Ms. Gonzalez. I'm not gonna argue with you.
No, sir, I'm not trying to argue with you, sir. I don't think the drug tests are, you're not